Joining me now is Jeremy Saland. He's a criminal defense attorney and former district attorney in Manhattan. He's going to try and help us make sense of the legal aspect in all of this. So, Jeremy, when President Trump talks about releasing all pertinent grand jury testimony, kind of break down for us, what sort of information would that entail?
This is really just a ruse, and you are going down, not you personally, but the public is somewhat going down a rabbit hole and chasing his own tail. And what I mean by that is the evidence that people want, this witness list, would not be a product of a grand jury subpoena and would not be protected by a grand jury secrecy. It would likely have been obtained, if not in fact obtained, by way of a search warrant. A search warrant would not be protected, and the materials from a search warrant would not be protected, like a, for example, bank statement that was subpoenaed with a grand jury subpoena to the grand jury. There was nothing preventing, really, the Department of Justice to release this witness list if it exists in this letter, because, again, it would not have been secured pursuant to a grand jury subpoena in a grand jury. This is really a farce to distract from the storyline, to say, hey, I turned over or tried to turn over and a judge shot me down. And that's simply not true.
And is this something that ever happens? I mean, how often does a grand jury unseal transcripts like this? Would there ever be a legal reason for something like this to happen?
Certainly would be. For example, if there was needed as part of a criminal investigation, you hear about it if there's some military issue, or even on tribal land, there's a court proceeding or something that needs to pull that sealed information out. But we look at historically, and there's a Second Circuit decision not too long ago from the 90s, I believe it is, but you hear from Richard Nixon historically saying, let's get some of this evidence out that was sealed. The danger to the public doesn't exist anymore. The secrecy is not necessarily that important as it used to be. The Rosenbergs, that conspiracy case from espionage case from a long time ago, historically. So there is a precedent. But again, we're being asked to move the ball. The evidence that the public wants to see of this witness list is not protected by the grand jury and likely would never have been presented into the grand jury.
So is it your belief that if you truly wanted full transparency in this matter, the grand jury would not be the route to go? Who would be, or where I should say, would the route take us? Who should we be asking for this?
His first name is Donald and his last name is Trump. And he is the person who can say to the Department of Justice, it's in that file, share it. He's not going to do that. He's going to blame a judge. But I'll close with this piece that's important. If you're investigating, which you were at Epstein, for trafficking these young girls or anyone, it's not the Johns and all the people that allegedly use that service that would be part of that grand jury proceeding. It really wouldn't be relevant. It's not there. Honesty and truthfulness is, if it exists, which people believe it does, then Donald Trump needs to man up and release it.
So what you're saying is that the release of this information, not only will it not provide the information that we're looking for, that it could potentially serve as a cover for him. He could say, here's everything I've given you, but in reality, the actual stuff you're looking for isn't in this tranche?
Right, but it's also realistic that the judge is going to say no because you have witnesses who are alive still. And unless some of the witnesses may have shared some of their story, and then you could say, well, you know what? The danger to that person doesn't exist because there was a civil litigation or they've shared it in the press. And I'll release some of it. But the information that the public is demanding and some of his base really wants, it's not likely there. It wouldn't be in the grand jury because it's not relevant to whether or not Epstein committed these crimes for which he was indicted. That material, which has been secured from a search warrant or shared some other way, would be in a file that the Department of Justice could release with Donald Trump's AOK.
Yeah, and then you mentioned the legal aspects that could be associated with this, that could lead to a judge saying, no, you can't release it. I mean, we have Ghislaine Maxwell's case. That's on appeal right now before the Supreme Court.
Right.
Could that be one of the reasons the judge will say, no, we're not going to comply with this?
Absolutely, absolutely. You know, again, you want to maintain the secrecy, the protection, the integrity of that grand jury proceeding and all those witnesses, so you don't generally release it unless, for example, as we discussed before, there was a separate criminal proceeding, for example. But even if the judge agrees, you're not going to get what you want. And when the judge doesn't agree, Donald Trump's going to point and say, I try to do my job. I try to be honest and transparent. But this is anything but that, period.
Okay, Jeremy Saland, thank you for bringing it to us straight today. I appreciate it as always.
My pleasure.
Joining me now for